Welcome to the June 2012 edition of Legal News, where we review new appellate and Supreme Court decisions that may affect the outcome of your own case. In January 2011, in the case of Rahman v. State, the Washington Supreme Court decided whether an employer is vicariously liable for injuries to an unauthorized passenger in an employer's vehicle. In this case, Mohammed Rahman was employed by the Washington Department of Ecology as an intern during the summer of 2005. His employer instructed him to drive from Olympia to Spokane in a state-owned vehicle to meet with an engineer and inspect a construction site. His employer did not know that he was bringing his wife Rizwana Rahman on the trip, in violation of department policy. On the way, Mr. Rahman misjudged a curve in the road, struck a tree, and rolled the vehicle several times. Mrs. Rahman was seriously injured. She brought suit in Superior Court against her husband's employer, the state of Washington. During the lawsuit, Mrs. Rahman claimed that the state was vicariously liable for her damages under a legal cause of action called respondeat superior, which literally means let the master answer. The Superior Court dismissed the case, agreeing with the state that the employee's use of an employer's car to transport an unauthorized passenger was outside the scope of his employment. Mrs. Rahman appealed. The Washington Supreme Court agreed with Rizwana Rahman, deciding that an employer is vicariously liable for its employee's acts of negligence, even when it does not know its employee is transporting an unauthorized passenger. This case is important because if you are injured by a worker who is traveling for business purposes, his or her employer may be held responsible for your damages. Legal news happens fast and can control the legal outcome of your case instantly. Feel free to check back here for future editions of Legal News. I am James Banks for bishoplegal.com.